Hi, I'm Mpumelelo, the host of the Eyewitness News podcast, Above the Law, the Senzo Meyiwa trial. The mysterious murder of the loved South African footballer has kept the country on tenterhooks for years, 8 years to be exact. Finally, after years of what seemed to be a case gone cold, 5 men are being tried for the 2014 crime. Join me as we take a deep dive analysing court proceedings as they unfold in this much-anticipated trial. We meet weekly on Twitter Spaces when the trial is in session to take a look at the week that was, bringing legal insight to shed light into the technicalities of the trial. But most importantly, you get to ask your questions and make your contributions on what stands out for you in this history-making trial. For now, here's the latest episode on what happened in the Senzo Meyiwa trial this week. All right, we have Mpumelelo Zikalala, who is joining us now. He's our guest for this space. So I'm going to start. Thank you so much for joining us. My name is Senzo. I'm a member of the EWN team, the lead reporter in the Senzo Meyiwa trial. I'd like to thank everyone who's taken the time. This is a first for the EWN team. So we're really excited. I'm excited to be doing this. And I'm glad to see everyone here present and ready to interact. I think first I need to let you know why we are here and just an understanding of why we've decided to have this space. I don't think spaces need any introduction, especially to you guys who are on Twitter. So that's very clear. This platform is one that we have all been using, I think, and it's one that I am using quite a bit in the covering of the trial and my coverage of the trial. I live tweet every day, or at least I try to live tweet as consistently. But from the live tweeting, I've realized just how much interest there is. So I have come here to have a conversation. I don't have all the answers. That's why we've got a legal analyst here to help us through any of the questions that you may have, help us through any analysis so that we can be able to be on the same page and have a clearer understanding as we move to the next witness in the Meyiwa trial who's going to be taking the stand tomorrow. So I suppose that's why we're here. I'm going to ask Mpumelelo. I have been inviting him to be speaker, and I appreciate any of your input on what we can do better. So yeah, just let us know, and we are ready to try. So, really quick intro. Most of you who are here should know Senzo Meyiwa trial kicked off this year in the Pretoria High Court in April, and we have been covering this trial as the EWN team since then. It's been 5 months, and we've only finished testimony from the second witness. And I want us to analyze the testimony from the first 2 witnesses that we've had. That was Sergeant Thabo Musia, who is a forensic police officer, as well as another sergeant, Sergeant Mlungisi Mthethwa, who is currently a sergeant but was a constable at the time of this crime, and he was the first responder here. So we're going to be analyzing what we heard from them this week, and anything that stood out for you, please let us know. I'm going to invite Mpumelelo. He's now a speaker. Mpumelelo Zikalala, legal analyst. Maybe just kick us off with this. Your observation maybe firstly, on the trial so far. It's been 5 months. I've never seen a trial that takes 5 months for one witness to finish on the stand. But you're the legal mind here. So what are your thoughts and your views on the trial thus far?
Let me say I'm also very proud to be the first guest in the inaugural Twitter Space session in which we're discussing a matter which maybe may see as being too far-fetched from them. However, it comes home to us in one way or another, because it's not only the Senzo Meyiwa trial in which we are looking at. We are looking at the state of our law enforcement agencies. We're looking at the state of our justice system. Is it able to bring those that ought to be accountable to book? Or is it a matter that we are being investigated, or we have investigators who are not competent enough, and we're going to have prosecutors who are not going to be competent enough? Then the most important question then is, where is justice in all of this? You've alluded to something which is very important. You say that one witness has stayed in the witness box for close to 5 months. But let me add on to that. You have a matter which has been investigated for plus minus 8 years. Now, one would ask, what is so complex and so an issue with this matter that it has to take 8 years to investigate? And after those 8 years of investigations, you then have 2 case dockets. You have an NPA in which, when you look at it, seems to be not be clear on the strategy in which they seem to be focused on. They don't really know what they're doing, or seem like it at this particular stage with these 2 witnesses. And at the end of the day, they're not inspiring any confidence, let me say, to me. That's the question in which we must ask ourselves moving forward with regards to this matter. But then let's also zoom in at the way in which the court works. Now, we have 2 important documents or 2 laws which are going to come into effect. One is the Constitution of South Africa, where Section 35, if not mistaken, dealing with the rights which are then associated with accused persons, in which all the individuals that are in the witness box, those rights accrue to them. The right to be given sufficient information before the start of the case, so that you're able to prepare your defense adequately. And then linked to that is the Criminal Procedure Act that details the procedures that ought to be followed when prosecuting this type of matters. Now, when a witness is then called into the witness box, there are 3 phases in which are going to apply. First one is the examination in chief, then you have your cross-examination, and then you have re-examination. Examination in chief, that's where you bring out your evidence without being interrupted. So we basically ask the question, tell us what you know. There are certain instances of clarity which are going to seek here and there, either from the prosecution or from the court. And then you have your cross-examination, which is meant to be the extractor of the truth. So you want to know, are you really telling us the truth? The way in which I'm going to do that is to repeatedly give conflicting versions which are not maybe in line in what you have stated earlier, just to test your version of the truth, whether it's the same, regardless of how I put it to you. And then highlight instances of conflict where there are other witnesses that have testified in the matter, which is why you would see now and again the defense counsels would raise statements which have been drafted by or attested to by other individuals and say, but Mr. So-and-so is saying this is what happened, what's your response to that? And then you have re-examination, which is more of doing damage control from the part of the state, where you say, let me bring clarity on instances in which you may have been perceived as being not truthful, and then you are able to bring them all together and make this matter understandable. What are we trying to achieve in all of this? Let me separate it from the defense and also separate it from the state. The state is simply saying, we have the only version of events in which the court ought to believe due to its accuracy, due to its probative value, due to the manner in which it was collected, due to the many instances of consistencies that have taken place. So we want you as the judge to believe our version of events. So we will be able to prove beyond any reasonable doubt. So we are removing any instances of doubt, which is reasonable, that the sequence of events may have happened in an alternative manner. Now, for the defense, their only objective is to plant those seeds of reasonable doubt so that at the end of the day, you then come back and say, the probative value of this evidence taking place in this particular manner is probably limited. The weight in which you must attach to the evidence provided also should be limited, because a person in the shoes of an expert, for example, shouldn't do what they are doing, or the way in which they have investigated this matter, it is so bad and so out of line to such an extent that we can't extract any truth in the evidence in which they are producing as an expert evidence. So we urge you as the court to not to put any value on it. So we are dealing with the reasonableness of we are planting those instances of doubt in all these spaces or in all this evidence which is being produced. Now, the 2 witnesses that have come to or that have been in the witness box are very important. The first one is an expert witness. I'll choose to call them expert witness, even though maybe they've been discredited as such. The reason why I say so, if you would say to anyone on the street, are you a forensic investigator or do you work for the police and you collect forensic material on behalf of the police, they would say no. That means a person who's collecting evidence in that particular manner has gone to school for it, has been trained, has done it a number of times, so they know exactly what to do in terms of collecting evidence, and they know the objective of why they are collecting the evidence in which they're collecting and how it should be stored and how those particular affidavits should be drafted. With the number of years that they've been in the police force, when they go to court, they know exactly what to do and how to talk, so that at the end of the day, they're able to display a much more coherent picture of how those instances or that evidence was collected. That evidence is crucial because it fits in with the greater puzzle of then saying, here is an independent analysis of the evidence which was collected on the crime scene that enables us to determine that the individuals who are in the witness box are indeed the ones that committed this particular crime. So if you're going to look at the bullet jackets, fingerprints, the way in which the scene was made and collected and protected, that goes into the integrity of the information that you have provided. If at the end of the day, it is proved that there are certain things that didn't go correctly, then the reasonable doubt has been planted, which is why we see when Advocate Mshololo and the advocate for the accused 1 to 5, the only thing that they're focusing on is saying you didn't do a good enough job. A reasonable person in your shoes or a reasonable forensic investigator wouldn't have done what you are doing.
Yes. In the beginning, you've spoken about how you're not convinced of the strategy that's being applied here by the state. And it's an important question to ask because by this time, you'd imagine, even though there hasn't been a lot of clarity about what may have happened, right? Or whether or not the men that are currently in the dock, are the real people or the culprits, we should have an understanding of what the state is trying to prove. But instead, we're left, especially now with the second witness that's taken the stand, and their information and their evidence not corroborating what was initially said by Sergeant Musia. I don't know about you, but I'm left even more confused, at least about what the police did, and what the state is trying to prove by bringing these two to the stand.
You must note that from a strategy point of view, the state is not to play out or play open cards. So they're going to say, we want to hide our strategy as much as possible so that the defense is somewhat surprised, and I say that in inverted commas, as to what we're going to do and how all the puzzles are going to fit in at the end of the day. But that does not take away that even the single puzzle piece that you've brought to book or you've brought as part of the evidence must be able to suffice the test of being guilty beyond reasonable doubt. So if you're not going to be able to prove that, then you're going to have a problem. The second reason why I say that, you have an instance where there are two dockets, meaning there are two investigation reports, let's call them that, or statements which may be in conflict with each other or may complement one another. Any reasonable person would say, I want to see what the second docket has so that I can be able to see what I can use to bolster or to assist my case. I also want to see whether are there any other witnesses who are saying things which are inconsistent with what we are saying. Remember, we were not there when this particular incident took place. We are simply trying to piece in the pieces together. And the only way in which we'll be able to do that is look at the evidence, look at the statements where there are conflicts. You then come back and say, why is there conflict in this particular manner? You go back to your investigating officer and say, I need more information pertaining to 1, 2, 3, 4, 5 so that I can be able to go to court. If you are going to go to court and only be informed of the second docket while you are standing up, to me it says you didn't prepare adequately. Even after that, you are made aware that there is a second docket. Why don't you stand down the matter, go back to the office, bring the investigating officer in and all the other people that are investigating this particular matter and say to them, let's go through these two dockets and see what we can use and can't use. Because if you don't do that, you are going to have people who are accomplices that are going to be let free or that you can't use in your own case or that are going to be used by the opponents to discredit your own case. So it goes through the law enforcement agencies first as to, did they really investigate this matter in a proper manner or in a manner in which a reasonable police officer would have done?
Yeah, except, I'm left even more confused around that second docket because the initial idea and the understanding was that the state didn't have it. They Advocate George Baloyi stood up to actually say he doesn't have the docket. And then we hear, this week around the special entry arguments that actually the state and both defense parties were made aware of the second docket. You would imagine the state would have at least worked to get their hands on it, even though, they didn't have it in the very beginning. But it seems there's been no attempt to get their hands on the second docket until the very last minute when Advocate Defo introduces it in court.
That's the one thing in which the court ought to have investigated. I did see it this week. They sort of tried to do damage control, which was done correctly, in terms of saying the disclosure of information is not something which is exclusive. We don't do it because it's a privilege. You ought to do it in terms of the Constitution, in terms of the Criminal Procedure Act. We don't work in the manner in which we work in movies, where evidence would come in the last minute with someone bursting through the door. You are given it well before time so that you're able to go through it. So if you have access to a second docket, as the prosecution, regardless of whether that particular evidence is against you or is going to help exonerate my client, you ought to give it to me. It's a rule. You can't negotiate on that one. So which is why it was important that the contents of the second docket ought to have been stated much earlier, which is why it's a bit puzzling again as to why the state was firstly denying it and then at a later stage agreeing with it. The impact of that is that the application which was made this week, 317 application of irregularities, that's where you start to say the state is not playing fair or in accordance with the Criminal Procedure Act, is going to tarnish my rights per the Constitution. Can you please look into it if I were ever to lose this particular matter? I was not given information adequately or within the start of the case. There are certain things in which I'm having to deal with now because I haven't had preview or wasn't able to deal with them at an earlier stage. So when you are making your ruling, you must have that at the back of your mind as a presiding officer, that I may have not been able to prepare adequately for this particular matter going against my right. So again, the state is shooting itself in the foot by not being able to provide information. Added to that, it doesn't inspire confidence if the same institutions are not going to communicate with each other and tell us this is what we have.
I'm going to open for contributions. So any questions and any comments will be welcome now. But while we wait for that, Mpumelelo, even after having heard from the second witness, because this week, finally, we got the privilege of hearing from a second witness, and this was a first responder. This was a Sergeant Mthethwa, but at the time he was a constable, very junior, and the defense has, pushed really hard to prove the fact that Mthethwa was a junior and that he was, with a colleague that was also a junior, a constable, and the fact that they were also accompanied by trainees. And, the defense is trying to prove that this was compromised from the get-go. But, even hearing from Mthethwa, we now have the ability to at least compare notes between Mthethwa and Musia. And not only are we left with questions, there are glaring inconsistencies around very important issues here. I don't know, maybe I'm placing a lot of importance on some of these inconsistencies, issues like timelines, issues like how, Sergeant Musia says he was called to the scene after midnight. But we heard from Mthethwa that he saw Sergeant Musia before he left the scene, and he left at around 10 p.m. or just after 10 p.m. We've heard issues around, the evidence that was found on the scene, the bullet jacket that was found on the counter, and how we heard Musia saying, it was found behind the jars on the table. But then we heard the sergeant saying that he saw it on the floor. These are all inconsistencies that I think are glaring and are really concerning. Are you sitting, as a legal person, are these weighty inconsistencies? Could they at least find us, compromising the state's case in any way? Or are these just on the surface? Are they, it's been 8 years, people forget. Is that what it is?
No, they're very important, because let's remember what the state is trying to do with these two witnesses. They're saying the integrity of the crime scene was preserved at all times, meaning that the information that would have been collected at the crime scene must be trusted by the court. And if it is pointing to the 5 accused who are in the witness box, then the court must come to the only conclusion that they are the ones that perpetrated or are the perpetrators. Now, if you're going to attack the integrity of the scene, was it protected? Is the accuracy? If we see something together, we should be able to relate things more or less the same. There may be inconsistencies here and there, but they can't be glaring inconsistencies. And if at the end of the day you are going to be able to prove that, the scene that you actually combed or you collected from was already compromised at the time of you collecting that information, it goes straight to the integrity of the crime scene. You could have saved that by saying, as a state, when we came there, we could see that someone had cleaned, but from the cleaned crime scene, this is what we're able to collect, because you are then able to show that what you are saying is the truth. You have nothing to hide. There are no things that have been planted, and the information that you've collected, even though the scene was compromised, at the end of the day, you were able to extract from it. What again is showing from the side of law enforcement agencies is the lack of training. And it pains me to say this, because one asked the question: if I were to be involved, or if I were to die and be murdered, that means my family would not know what happened if the same policeman would present on scene. So it's one other thing in which I always say this: Minister of Police, the Commissioner, should be looking at this matter and sort of saying to someone, please draft a manual of how not to do investigations, taking out from this particular matter, so that we don't repeat the same mistakes. But the crux of the matter, why they are focusing on these policemen, they are saying, you are a trained South African police service official. You know what you do when it comes to crime scenes. You shouldn't be overwhelmed just to the victim. You should be overwhelmed just to the place in which you are going to interrogate. All that you are there to do is to protect the crime scene, and you ought to have done that. It doesn't take an expert to do that. In some instances, it's just purely common sense.
Yeah. I do see your request. Let's start with Domkop is ready to make his contribution as well. Let's hear what you have to say.
To your guest, Mina, I just have one question to say. Why is because my question comes from, if you listen to Mr. Mteto, you would realize how Mr. Mteto was frustrated when he was told he cannot refer to Mpumelelo, and he must speak about things that he saw himself. And that's where he got frustrated, because much of what Mr. Mteto found there was related to him by Mpumelelo and the said uncle. So my question is, why does it seem like state is not willing to call the people in the house as witnesses? What strategy are they playing? Are they having here? And what benefit are they going to get from not calling those people who were in the house? That even related information to police officers who are now told you cannot speak about them because it will be hearsay evidence. That's my question. Thanks.
Maybe Mpumelelo, before you do unmute yourself, just for a bit of clarity there, Domkop, thank you so much for the contribution. So the state is saying that they are going to be calling witnesses from the house to come. They're just not revealing who. And it was clear this week when Advocate George Baloyi was asked by the defense whether or not Gladys Khumalo will be taking the stand. He could not say yes or no. He couldn't bind himself at all. And maybe Mpumelelo can clarify on that. It seems there is, resistance. He does. The Advocate Baloyi doesn't want to find himself in a position where he commits to having Gladness, and Gladness is the mother to Kelly Khumalo. He doesn't want to find himself in a position where he's committed to having her take the stand and then not bringing her. But I do get a sense that the defense is going to be subpoenaing her if they feel the need to have her on the stand. Mpumelelo?
You see, that's why I was saying earlier, the state is saying, I'm going to keep my cards close to my chest. I don't want to reveal anything as yet, because I don't want to give the defense a head start in terms of preparations. The second problem which I'm going to have, I don't think there's anything more difficult than going to be a witness in this particular case, because you go out, your evidence is analyzed, there are a number of people who are going to have comments about you, and you then forget what you are there for, which is to simply tell the truth, and then the answer. You saw it with Wabumteto Nyambos, where he would get very agitated in terms of his responses for no particular reason, due to the pressure in which they're facing. So you don't want that pressure to be applied to your witnesses before they come to the actual witness stand. And you also want to make sure that when they come, they're also on their side. The last thing that you want is to have a hostile witness presenting your case, which may end up killing it at the end of the day. But then it moves back to my earlier submission of saying, all that the state should have done was to have these sessions with the witnesses earlier, and then be able to check, this is the witness that I can use, this is the witness that I can't use. To say, or not to come up with a clear answer of saying that you are going to use them or not, leave the defense in a very difficult position, because I don't know whether I should submit their evidence, their statements as part of the witnesses. I don't know whether I should prep my side so that I'm able to subpoena them. Endless delays are going to come up at the end of the day if they are not able to curtail as part of these things. But let's also remember, it is still very early stages. There are only two witnesses that are there, and the witnesses which are on the table right now, they seem to me as setting the scene, or setting the crime scene. Other witnesses detailing as to what happened at the crime scene are going to come in at a later stage.
Before I open up for Constitution first, Mpumelelo, I'm sitting here thinking that from the witnesses that we've heard already, it's very clear that the managing and the containing of the crime scene wasn't done as was supposed to happen. It was compromised. And it's clear from the testimony by Umthetho this week that he didn't see it as a crime. He says he didn't see it as a crime scene when he went there for the first time because he didn't have enough information. There's clear evidence there, even from him, that scene was compromised. It was bare. At least for a few hours. And the sense that I'm getting there is that is sufficient for the defense to at least prove that anything could have happened at that time. Do you get a sense that that's a major knock on the defense, on the state's case? And once you're done, Constitution first?
I would say it is still very early stages. So let's remember what the state is doing is only one part of many other strategies that one can use to bring the accused to the actual crime scene. There may be, when you are insinuating here, I don't have the actual facts. There may be cell phone evidence which is going to place the accused in that place. There may be eyewitnesses which are going to place the witnesses in that place. There may be fingerprints that have been taken who are going to link the accused into that particular crime scene. So at this stage, I think what the state was simply saying, or the strategy of the state, is to say, this is the crime scene as we know it. This is what was provided or taken from the crime scene. This is how it was secured, as bad as it was. And we are going to lead on from there with everything else. So the other, I would say, more important witnesses are still going to come in, and those ones are the actual individuals that were in the room, who will be able to say that a person walked in, pointed the gun, this is what was said, and this is what I saw. So at the end of the day, I think we may give the state a bit of time to get itself together, but for me, I have a few questions with regards to their strategy, taking into account what these particular witnesses are stating at the moment.
Constitution first, and then the Trinity God. You can follow after that.
Okay, no, thanks for this space. What I witnessed in these weeks, I may have not heard the other witness, but this one of Nyombos, Mr. Mtetu, one, I picked up that there is a hostile witness. Two, it's like he was dragged to that case. Three, I just sense that some of these witnesses use this issue of not understanding or not being comfortable to speak English just as a delay, so that they can think about the plan, what to say next, whilst the other translator is busy translating into English. Lastly, the question that I would want to ask, aren't these witnesses like Mr. Mtetwa and the one before privileged to the information which is coming from this witnesses whose statement were shown on TV? Because there was a thing which was shown of Meg Peary and them, and it narrated timelines. But this guy seems as if he's also seeing it for the first time. If he had seen it initially, surely would have been able just to narrate his story as well, aligning to whatever would be shown by Advocate Mshololo. But it's just that there were just too many gaps of taking to hospital and coming back and not wanting to align himself and still call the house. He still says it's the house. Even now he's a surgeon. And he was a constable then. He's the surgeon, but he doesn't want to consider that it is a crime scene and it is no longer a house as he wants to make us feel. Thanks, Host and Mr. Zikalala.
Thank you. Maybe let me start with your question. Ordinarily, you wouldn't want your witnesses to read each other's statements because you don't want them to fill in the gaps. The authenticness of the evidence which is going to come in is going to be extracted from what that particular witness is saying. If it is too synchronized, then to me as the presiding officer then tells me that no, these people are concocting whatever that they've said, they've read, and they are presenting one as if it's a school project. We can't see the same thing and describe it in a similar manner. There are going to be discrepancies here and there. However, they can't be too large. They can only be limited to sort of minute things here and there. So I think on that one, the only statement that he would have been privy to is his own statement, which was written at the time. Just remember, they wrote the statements probably about 7 or 8 years ago, and they're only sufficing now. And the defense was then handed over the statements that they wrote 8 years ago. So there are going to be instances of inconsistencies because they're going to not remember what they wrote at that particular point in time. What the state should do then to sort of do damage control, during re-examination, you then say to him, please come and clarify what you mean by saying this was not a crime scene. If you still persist with the point of saying that because you did not identify it as one, and then it's not, then okay, we'll give you that, but the presiding officer would have something to say about that at the end of the day. And it does say something about you if you're a policeman, you can't even identify what a crime scene is. Then the other one, you're looking to something which is very important, the balancing of the right of the media and the public to have access to these type of cases, them being broadcast in national television so that everyone is privy to, because you can't take all the witnesses which are in this case and go lock them up in a certain place and say, don't watch any media coverage pertaining to this particular matter up until you come and testify. So you are going to have instances where they're going to be asked, have you been looking at this matter? Do you know what the evidence has been stated? So you can be able to tailor make it to what has been stated earlier. But the presiding officer's tactics will be able to deal with that and be able to sift through the lies and the truth, and they're able to use the truth when they come to their determination. And then lastly, being a witness in any criminal matter or any matter, it is not nice because you are there on the basis of relating what you have stated, and you are going to find a certain sort of resistance during cross-examination and certain type of insinuations where they are going to call you an incompetent police officer. No one wants to be called incompetent. Even I would be at pains if someone would say you're a very bad lawyer. But at the end of the day, it's something that you must be able to stomach. And we always try and tell clients this. It is not about the putting or the conveying of a message in a manner which is going to be understandable to another person. It is all about telling the truth. I will do the work of mending certain integrity things that have taken place or any inconsistencies that have taken place. All I want from you is the truth. And I think what the state should do in any other witnesses, in fact, all of them, should say, go into the witness box and simply tell the truth, and everything else will be taken care of by me.
All right. Thank you so much for that. I do have questions actually, around you saying that witnesses should not see each other's statements. But let me give you that question after the Trinity Guard makes his contribution.
Okay, as somebody who actually, myself as somebody who actually studied law in general, especially criminal law as well, I would like to say there is no way such a huge country such as South Africa would actually have such an easy case that can actually drag for more than 8 years without somebody trying to protect somebody. Like in this case, one thing for sure that I've observed is like the people are trying by all means to make this case to drag. It's actually the judiciary and the state. And if you try to look at it, it means somehow there are people that are actually trying to be protected. It does not make any sense that a crime happened within a house and there were a number of people in that particular house, but those people have not appeared in court for almost 8 years. And even at the point where the case is quite hot, they're still not yet appearing at the court. It seems a little bit fish. It looks like we're just playing around waters, but the truth is already known. But they're just trying to protect certain people. But at the end of the day, one thing for sure that I'll say is like the truth will definitely come out, regardless of how much they're actually trying to protect. That's all I just wanted to contribute. Thank you.
Thank you so much to the Trinity God. And I'd like to actually hop onto that contribution by you. Mpumelelo, maybe you can help us with this. So the one thing that's been going through my mind throughout this trial really is just how much leeway or how much provision is made for the memory, right? And just, it's the human nature that people will not remember things to the T in terms of detail. And so you will hear, stories varying at some point. You'll even hear questions around whether that was the car that was parked, Kelly Khumalo's car that was parked right outside the house. People will, we heard the state this week asking one of the witnesses to clearly identify the vehicle. But how much provision is made for that? And at what point does it become a lie and not a mistake?
You see, it is understood that we are going to make mistakes. We're human beings at the end of the day. We are going to forget we are human beings at the end of the day, which is why you have those three chances of you presenting evidence: examination in chief, cross-examination, and re-examination. So in the only thing in which the court will then say how what's the probative value of what you are presenting? How likely is this thing supposed to happen in the sequence of events in which you are telling us? Now, your experience will then come in, your the manner in which you've then collected the evidence will then come in. And then secondly, we would then ask, how should we really trust you in what you are saying? So the more consistent you are, the more external evidence that helps to prove what you are saying comes in, then the accuracy or the truthfulness of what you are saying should then be added to the evidence in which you are then providing. So once that has been done, the court will then weigh up all this evidence, not in isolation but in unison, and then say, let's go back to the reasonable doubt argument. You must be found beyond reasonable doubt that you've committed the act in a manner in which the state says that you've committed the act in. So if there are no instances of doubt, then the court is going to find you guilty. If there are reasonable instances of doubt due to people not doing their job, for example, not protecting the crime scene, collecting information which is tainted from the crime scene, presenting information during the witness sessions which cannot be trusted, then that reads into the reasonable doubtness that should not be there at all. So yes, we are aware that people are going to forget. We are aware that people are not going to be accurate in presenting their matter. But there's a difference between an honest mistake and someone lying. But then let me move to what I think it was Trinity was saying, which is why I'll always come back to our political heads and the higher echelons of saying, they should be then saying, how do we bolster and make sure that the investigations training part of it is done correctly? How do we make sure that we're able to account to people of South Africa and say we're able to investigate matters adequately? South Africa is not a playground for criminals. And most importantly, how do we make sure that we're able to solve these cases as soon as possible? They are the ones who should be accounting if something has not been done correctly. I would like to say that for the sake of the Meyiwa family, that the truth must come out at the end of the day so that they're at peace and they know what exactly happened on the day when their son was killed. If that doesn't happen, then I would have said justice has certainly failed them.
Mm-hmm. I'm wondering, Mpumelelo, just how much does accountability and just making concessions, what does it count for in a matter of this nature? Things like Sergeant Mthethwa not wanting to concede that the house was a crime scene, and the point that's made by advocates in Mshololo that at the point where you got a call that there was a shooting in progress, where did you think the shooting was happening? And even at the point that because the sergeant says he arrived at the house, and when he got in, he found Kelly Kumalo's uncle there, who was there, and he said that there'd been some shooting. Good to learn, I think was his word. Right? There'd been some shooting going on, but he wasn't sure what had happened. At that point, Jolola says it should have rung in your head that, listen, this is a crime scene. So, I mean, I'm sitting here thinking accountability and concessions would really help with speeding this case up. The fact that I don't think police have anything to lose in saying, yes, we could have done a better job at containing the scene, but that doesn't take away the responsibility of the people that they believe, or that the state believes are behind this.
At the end of the day, they're human beings, and it's going to be very difficult for them to concede that they are wrong, especially when they come to court as police officers that are trained to handle this type of things. But you see, as a cross-examiner, or if you're the defense attorney, you don't really need to have them spell it out that, yes, I was indeed incompetent, I didn't do my job correctly. You just show those elements in which they are going to answer and say, I didn't do this, I didn't do this, I didn't do this. If you then say, at the end of the day, can you see that all those read together point to you not being a competent police officer? And obviously, any human being would say, no, it doesn't. It means I did my job. Maybe I did a few mistakes here and there. End it there. You are then going to argue your matter at the end of the day when you are making your closing arguments, or when you are making your 174 application, which is an application to say that the state has failed to prove or to submit any elements in which I must answer to as the accused, so it must be dismissed from the instance. So it is not really to try and force them to concede within the witness box, but highlight those elements that will be able to prove that indeed they haven't done their job. And in this case, the mere fact that he still does not concede that it was a crime scene, even in re-examination, it has proved the case for Advocate Mpumelelo and the defense team. They've done the job in what they needed to do, so they don't need to do it anymore. But at the end of the day, you then wonder, when you take a witness to court, you sort of prep them as to what type of questions they are going to or they may receive with the hostility. It's not a nice place to be. Not everyone goes to court on a daily basis like us. So you do say to them, this is the hostility that you are going to find, by trying to keep a cool head and answer the questions in which you need to answer them. Because what has been done now, or what I listened to last week, he seems to be a bit evasive and says, okay, if you say so, then it's fine. For him, that's an okay answer. But for the state, that's a very bad answer, because that's a witness conceding that, yes, they were wrong, and what the defense is saying is indeed true. So at the end of the day, a bit of case prep or prep when it comes to what they need to go and how things go about within the court of law. They need to state it to them so that they're well prepped when they go to court.
Mpumelelo, please then address the issues around witnesses not being privy to what's going on in court. And this is an important one, because we saw Magdalene Munswami, who's the watching brief for Kelly Khumalo, the lawyer who's watching this for her. She was told to leave the courtroom at the very beginning of the trial, and the issues that were cited were issues around how Kelly Khumalo is going to be is potentially a witness who may take the stand, and so we cannot have her lawyer who's representing her in court. Now, this week, we heard Titi Tobani, the attorney who's representing the four of the accused. He says he saw Sergeant Mthethwa, watching proceedings while he was sitting outside. He says he was watching on his phone. Talk to us about the technicalities on that.
It comes from a general rule of saying that before you come and be a witness, you can't be part of the proceedings in any manner, because what we want is your sequence of events which are independent, not having it been heard or influenced by any other individual. But from practice, you would know that once a person starts relating evidence which is close or similar to another person, they've concocted or they've shared notes, and this is what they are going to state in court. And that is what you use to discredit their evidence moving forward. So it works for the defense in terms of saying, we will not give too much credence to what you have stated because you've seen these proceedings before. You know what exactly people are saying. There's certain statements that have been there in which we are using to prove that you are allegedly lying. You've seen them as to what is contained in them. But for the state, it doesn't really assist, because it simply shows that they may have tailor-made their evidence to suit what has already been stated inside court. It's a hard balancing act of saying, should we not broadcast this type of proceedings in your national television and all other media? The answer to that, I would say no, because at the end of the day, us as members of the public need to know what our courts are saying. I can walk into any courtroom and be able to sit and listen to what they're discussing, unless if they're dealing with a child, if I'm going to sit within where the legal practitioners are sitting. But as a member of the public, you can't do that. So if you can, then let's also allow the other individuals to participate in that. Balancing or protecting the integrity of the evidence in which you're supposed to give, then it's another factor altogether. But during cross-examination or the examination phase, you are going to get an opportunity of extracting and making sure that you're able to extract the truth from the lies. What I always say, the truth is always going to come out. The sequence of events cannot be tailor-made. They're always going to be in a particular manner, whether you like it or not. All you have to do is to go and tell the truth, even in instances where you are going to display or be perceived as someone who did not do their job correctly.
Right. Thank you so much for that. Unfortunately, we are going to have to wrap up very quickly. A throw forward for the week to come. So we're expecting Sergeant Mathebula to take the stand from tomorrow. And Sergeant Matebula is the sergeant. Well, then he was a constable who was with Mthethwa. So at the beginning of his evidence, Mthethwa spoke about how he just, clocked in for work for a night shift, and he was with Matebula. And so Matebula, we're expecting him to shed light, either corroborate the evidence that's been given by Mthethwa or shed any clearer, any new information. With this trial, I think anything's possible. So we're expected to hear from him from tomorrow. And thereafter, I believe that the state is going to go on giving more witness advice, or calling more expert advice, rather. So calling more experts to the stand before we get to who everyone wants to hear from, and that's the people who are going to be in the house. But thank you so much, Mpumelelo. Any parting shots from you before I let you go and end the space?
Nothing much except to say let's continue watching, and maybe I'm pretty sure that from these type of proceedings we are going to learn a few things or two. The law enforcement agencies, the powers that be, if I were them again, let me repeat, I'd be watching these particular proceedings attentively. If I were the minister, I would be watching these proceedings attentively and making sure that we are beefing up this training so that at the end of the day, we make the work of finding the perpetrators much more easier. I do feel like, again, very sorry for the Meyiwa family. It's not nice to see these ping pongs which is taking place within the court when all you want to know is who killed your son, and they must be brought to book. But I think at the end of the day, justice is going to prevail. Let's just give it time and allow our court to do its job.
Right. So Mpumelelo Zikalala, he's a legal analyst helping us through the Senzo Meyiwa trial. This podcast, well, it's going to be podcasted, but this space called Above the Law, the Senzo Meyiwa trial, with myself, Khomotso Modise. I am the lead reporter on the Senzo Meyiwa trial, and I will continue tweeting from my personal Twitter and from the EWN Twitter, keeping you in the loop on what's going on in court. But for now, thank you so much for listening. Thank you for joining us. We're going to do it again next week, I believe, and we're going to be further breaking down any more evidence that we hear for the duration of this week. Until then, though, have a fantastic Sunday and have a good week ahead. Thank you and goodbye.